So in this series, we're talking about substantive protections flowing from bilateral investment treaties, multilateral investment treaties, and domestic legislation providing for investment protection. It flows obviously from the previous sessions in terms of you first need to ascertain whether the particular entity or natural person is a qualifying investor, and then whether the investment is a qualifying investment, in order to ultimately rely on the substantive rights and protection provided for in bilateral investment treaties and certain domestic pieces of legislation. So what do we mean by substantive rights? So in most BITs, there are generally a few guarantees that are provided by host governments to investors for their investments, which are firstly the guarantee against expropriation without compensation, whether lawful or unlawful expropriation, the guarantee to be treated fairly and equitably, so the FET standard, the guarantee of full protection and security in respect of your investment, particularly your property, the most favored nation principle, national treatment standard, and what we would call the umbrella clause. So, and the most important would be also to ensure that from the investment treaty that you ultimately have recourse from an investment arbitration perspective, where if there's a violation by a host government of any of the guarantees set out in the treaty or domestic legislation, that you are entitled to go to an investment tribunal, which is essentially a tribunal that doesn't sit in the jurisdiction within which the host state is, but it's a supranational tribunal over which the tribunal will decide whether the host government has violated certain of the fundamental guarantees provided for in the investment treaties. Just one other point I need to point out is old generation BITs, which were negotiated by governments from 1994 onwards, provided for mostly rights for investors. There was no obligations imposed on investors when they essentially are admitted into a particular jurisdiction. So what you'll notice in most of these BITs is that an investor can then invoke these rights or enforce these rights through investor-state arbitration, but host governments do not have the similar rights. So there's no obligations on the side of investors, but rights. The obligations are more so on the state to ensure that these guarantees are given effect to, failing which the investors obviously can approach international tribunals for recourse. So it's important from a substantive protection perspective that you understand what the rights are that you're entitled to from a bilateral investment treaty or domestic law perspective, or any other investment agreement that might have been negotiated between a host government and a foreign national.